podcast where we talk about consumer-related issues and litigation in the class action space. I'm Christine Argentine. I'm a partner at Cypher Shaw in our Chicago office.
And I'm Paul Yovanik, and I'm a partner in the Chicago office as well. Today we're going to talk about a recent decision that came down from the Illinois Appellate Court on the Illinois Biometric Information Privacy Act. That was, I think, a big win for defendants, businesses. And while this one is in the employment context, it just kind of, I think, provides a little bit more clarity on this idea of who's capturing, collecting, and who's really liable under BIPA.
Okay.
And so in late January, there was a decision that came down against or in favor of two staffing companies who provided temps to their client. So there was two plaintiffs, staffing companies each sent one temp. So there was three defendants. It was the client, the two staffing companies against the two plaintiffs. In that case, the client used their own time clocks to enroll the temps in the clocks, and so basically they were the ones that had the contract with the time clock company, the vendors, and but nonetheless the plaintiffs decided to sue both the staffing companies in addition to the client.
And when you say client, you're talking about the company who brought in the temporary employees to work for them.
Yes.
Okay.
Yes. And so they sued all of them under BIPA, saying that you collectively captured and collected biometric information, you failed to put together a publicly available policy, you disseminated biometric information, and so what happened was the staffing companies took a look at this and said, well, and they moved for summary judgment, saying, well, wait a minute, they're not our clocks. They're not. We do not control the clocks. We did not contract with the time clock vendor. The only thing they did was assist in enrolling their own temps that they were sending to their client in the time clocks. And so what happened was the defendants, the staffing company said that's not enough just to say, oh, put your finger on the time clock. Now we're capturing it even though we don't possess it, we don't obtain it. And the trial court agreed.
And this is the violation that's being alleged against the company and the two staffing companies is 15B, is that
correct?
Right?
Yes.
And so that's collected, captured, purchased, received, or otherwise obtained.
Yes.
Okay.
Yeah, and so that really you can see where they're trying to kind of say like this is otherwise obtained at very least through your assistance staffing companies in enrolling the temps into the time clock. You've otherwise obtained this biometric data.
So essentially the plaintiff's theory is that by facilitating those temp employees in using the time clock, right?
Right.
Getting them registered into the time clock, the staffing companies themselves collected or otherwise obtained this information, for this biometric information.
Yeah, I mean, exactly. I mean, what the plaintiffs argued was that the enrolling, the instructing, and monitoring the clocks and the temps usage violated BIPA, particularly because their argument was that they were in possession, and really they found that there was a less direct action required because this possession is not found in section 15B like it is in other ones. Because they're saying, well, we're not saying that the staffing company possessed it, otherwise obtained it, it otherwise had some sort of involvement in the capture and collection. And so, but the trial court disagreed with that argument. And they found for summary judgment in favor of both of the staffing companies.
Okay.
And so they were saying that where the decision came down was the first thing that the appellate court said was coming into possession of something means it was obtained or otherwise received. And so there is no material distinction in these terms, and plaintiff's theory stretches section 15B beyond its text. The next thing that the appellate court said was that courts have rejected similar arguments where a party played a passive or ministerial role in connection with the use of biometric identifying devices. And in doing so, they leaned on some of these other phone and app-based biometric capture and collection, where when that information is localized to a phone, to the app, that the manufacturer is not collecting the biometric information.
And so in those particular cases, right, those cases turned on the idea that the phone manufacturer, the app creator, didn't actually have access to the facial recognition data.
Exactly.
Okay.
Yeah, and so that's it's again just saying, like, yes, we created the app, we created the phone, but the data that is being captured or collected is local. We don't have access to it. And you can see the parallel here with the staffing companies is, yes, the biometric information of our temps that we sent to our client is in this clock, but that clock is not ours. We did not contract with the time clock vendor. It is purely with our client. And so therefore, no matter what we did, okay, here you go, put your thumb down on the time clock, like, that's not enough. The court recognized there are instances, though, where someone who is assisting in the capture and collection or enrollment could have liability, but that would have to show some sort of control over agency. We saw that in some cases previously, where there's going to be agency and you're going to have a control over this entity that's capturing and collecting on your behalf.
Yeah.
Arguably they're saying here that was not the case, because the client, the staffing company's client, was using their clocks to capture temp time to figure out accurate timekeeping.
Yeah. So a great decision for defendants, because oftentimes in these BIPA cases we see multiple companies get brought in as defendants. And what I think is interesting in this case in particular too is the procedural posture at which this happened, right? It happened really early in the case, didn't it?
Yeah, so it did happen very quickly, and we've seen this a few times, and especially in Illinois State Court. You can come right out the gate with a summary judgment if you want, and we've done it in the past sometimes, and it really makes plaintiffs think, really hard. What do I want to do? You do have there is some strategy behind it too, because in a case like this, the plaintiff sought discovery in response to the summary judgment before responding. So that's Illinois Supreme Court Rule 191B. Right. And basically you have to put forth in an affidavit what discovery you need, why you think, where you think you can get it, what you expect to get, and basically you need to put forth, like, this is why I need this to respond to the summary judgment.
And why it creates a factual issue.
Yeah, or why it could, or if I understand it. And we've been successful arguing that, especially in cases like this where there's signed declarations from the staffing company saying it's not our clock. We did not contract. Like the argument on a Rule 191B motion for discovery is there's no discovery that could contradict that fact.
Yeah.
And so the court rejected the request for 191B discovery because there is nothing out there that you could receive that could say, actually, staffing companies, you did contract with the time clock vendor. It's just not there.
Right.
And so just because you want discovery or think you might need it, the fight is it out there? If it's not out there, you're not getting it.
Right. And what a great mechanism for defendants to be able to use, right? Because we all know that the real cost in litigation comes with the discovery and just the length of time that these cases can take to get to summary judgment. So if you're able to utilize a procedural mechanism like this out of the gate, with really strong arguments that there's never going to be a factual issue, that's really helpful for defendants.
Yeah, and it's something you think about when you figure out, do we want to remove this case real quickly if we're served in Illinois State Court? Do we want to remove to federal court? Because there have been instances where we've looked at it and said, well, maybe we can move for summary judgment right out the gate. It throws the plaintiffs off a little bit. It's available to us. It's harder to do that in federal court because of the rules of civil procedure and federal rules. So sometimes you think, yes, we could remove, but we also might be able to just get this case disposed of real early through declaration, fighting 191B discovery, and getting a summary judgment ruling like they did here. And so there's some interesting language that came out of the decision, where the Illinois Appellate Court really said, Section 15B regulates the acquisition of biometric data, not the proximity to it. And that's key because, again, we're talking about when these plaintiffs loop in all of these other defendants, and you had the contract, but you might have helped put someone's finger down on the clock, and you might have looked at the timesheets. All of that has to do with the clock. Well, that's proximity, and that's not 15B.
Right.
And
it's really, obviously the appellate court here is doing some statutory interpretation. Great to see the appellate courts making some of these decisions in statutes like BIPA, where there is so much litigation and so much there's a lack of clarity in certain areas as to what certain language in the statute means.
Yeah, and for the last several years, we would get a lot of Illinois Supreme Court decisions, appellate court decisions that weren't really defendant friendly. Whether it was expanding or making clear that the statute of limitations is 5 years instead of 1 or 2. The Rosenbach decision. Holding that every scan, that a mere technical violation of the statute is enough to have standing, or that every scan in, Cawthorn versus White Castle is a violation. Those were not helpful to defendants, but there was still a lot of, merits-based defenses or arguments that were still untested. So it wasn't the end of the world. It did make it harder for defendants to litigate these cases. But at the end of the day, we're starting to see decisions like this where we've got the appellate court really, looking at, and trial court, granting a motion for summary judgment saying this is too much of a stretch to hold these staffing companies on these set of facts liable under BIPA. And so with the conclusion was great. The appellate court said, well, Biometric Information Privacy Act is a statute that wields the impact of a grenade. It does not impose liability on everyone who happens to be standing nearby. And I just thought that was awesome. Everyone just, especially the plaintiffs bar, really kind of just, let's loop everybody in. You're all liable because of this clock that was contracted with this, but you all did something. It's like, no. Who's controlling, who's possessing, who's capturing, collecting, otherwise obtaining, and it's not everyone in the room. There's more of a focus, and so I think this was very helpful for a lot of defendants who are dealing with these co-defendant BIPA cases where there might be a little bit different relationship amongst the parties.
Yeah, great opinion. And I'm sure we'll see hopefully more opinions out of the appellate courts in Illinois on BIPA this year, and we'll report on all of them.
Awesome. Great. Thank you.